I can still say good morning for a few more minutes. So. And there's no brief on the other side, so you'll have your 15 minutes to proceed. And this is Cherconis versus Cherconis.
Hi, yes. May it please the court, my name is Attorney Joseph F. Salzgeber on behalf of the appellant husband David M. Cherconis, parties of the divorce case below. We would ask that the court accept the facts and statement of the case as written, insofar as there's no brief on the other side. This particular case involved multiple errors and abuse of discretion by the Medina County Domestic Relations Court involving the divorce of the Cherconises. A little bit of background due to the fact that this was a somewhat unusual case. The parties married back in 1984. They had 4 children as issue of their marriage. They divorced previously in November of 2007. Both parties were represented by counsel at that time. Mrs. Cherconis, Carolyn Cherconis, was represented by David Reel of Brunswick, and Mr. Cherconis was represented by Mr. Palmquist, Attorney Palmquist of Medina. In that first divorce, which was filed in 2006 and concluded at the end of 2007, David received the marital residence, which was his mother's home that he inherited in 1995, and agreed to pay Caroline $29,000 for her equity interest in the home. That's the home at 873 Lakeview Drive in Brunswick, Ohio. Caroline was given the option of remaining in the home if she so chose, because they had been separated and David was not living at the home at that time. But $719.89 of rent would be deducted monthly so long as she remained in the home. There was no spousal support ordered and no jurisdiction was retained on that issue by the trial court in the 2007 divorce. David is in the construction trades, which have been difficult since 2008. His wife, Caroline, was working part-time jobs. She's an STNA nursing assistant and also worked at Mark's. A 2012 foreclosure was filed by Third Federal Savings and Loan of Cleveland against the home, and David's sister, Randy Schneider, his older sister, obtained a $38,550 loan in order to get the home out of foreclosure, in part because it was the family home, their parents' home. But
let me just make sure I understand at that point, whose responsibility was it to make the mortgage payments at the time that the home went into foreclosure?
At that time, it was David, the husband's obligation. Due to difficulties he experienced working in the construction trades, the home fell into foreclosure in 2012. And then his sister, Randy, took out a loan from Key Bank in order to pay off the home and save it from foreclosure by Third Federal Savings and Loan. She expected to be repaid either by David or from the eventual sale of the home. In order to provide her with the necessary collateral that Key Bank wanted, David quitclaimed the home to his sister, which resulted in the trial court believing there was a potential violation of the mutual restraining order in the case as we come to the second divorce. The second divorce was filed in 2013. In the meantime, Caroline had never moved out of the house after the first divorce. She exercised her option to remain in the house, paying the $719 in rent that was deducted from her equity interest in the house. David moved back into the house in August of 2010. The parties remarried in October of 2010. They still had a 10-year-old child at that point. They still have one child, that child Joseph, who is in high school at this time, who was a minor issue of the marriage. They separated within about 8 months. In 2011, divorce was filed, and then the second divorce, which we're here on appeal, that became final in August of 2014. Both divorces were based on incompatibility. And I would add that Randy Schneider, his sister, was added as a party pursuant to the motion of Caroline's lawyer due to the loan and the transfer of the home into her name. The three assignments of error we raise, first of all, with respect to spousal support, we allege that the trial court erred and abused its discretion by awarding indefinite spousal support in the amount of $340 per month payable by David to Caroline through the agency until the death of either party or Caroline's remarriage or cohabitation with an unrelated adult male. We contend that the error and abuse of discretion was that there was no award of spousal support in the first divorce case back in 2007. No jurisdiction was even retained with respect to spousal support. And Caroline and David both had legal counsel back in the 2006 divorce case. The trial court applied res judicata with respect to David being awarded the home in the first case, but for some reason did not apply res judicata to the issue of spousal support, even though no jurisdiction had been retained after the 2007 case. The terms of the first divorce expressly permitted Caroline to remain in the house. The court relied erroneously, we contend, on the cases of Moore v. Moore and the Jernigan case, Jernigan v. Jernigan, for the proposition that the party's first marriage could be considered in determining spousal support in the termination of a second marriage. However, the facts were clearly distinguishable in this case from those of Moore v. Moore and Jernigan v. Jernigan. In Moore, the salient factor was that the wife was 56 years old, medically disabled, and unable to work, which is not the case here. In this case, Mrs. Cherconis, Caroline Cherconis, is 6 years younger than David. She was 45 at the time of the divorce. She's not medically disabled, and she's working 2 jobs. The parties also have comparable levels of education, both being high school graduates with no college. In the Jernigan case, there was a wide discrepancy in the amount of income, with the wife making between $13,000 and $15,000 per year in various clerical jobs, and the husband working for LTV in a union job, making more than 3 times as much. The salient factors in Jernigan were wife's lost educational and economic opportunities sustained over the entire relationship. In this particular case, as I indicated, Caroline's 6 years younger than David. They have the same level of education. She is not disabled and was in fact working 2 part-time jobs with a total annual income of $17,576, while David was unemployed at that time, so they were making approximately the same amount of money, given that he was receiving unemployment compensation. The case is further distinguishable where Caroline was allowed the option of staying in the marital home. In the other cases, parties divorced, they never lived separate and apart. But in this particular case, Caroline exercised her option to remain at the home where David was not living, and ran down her equity interest in the home as rent. So the court, in this case, really didn't pay attention to the previous divorce decree in fashioning the current divorce decree. It just looked at the duration of the previous marriage and bootstrapped it onto this marriage. It's our contention that the trial court erred by awarding an indefinite amount of, or an indefinite length of spousal support of $340 until death, remarriage of Caroline, or cohabitation of Caroline, based on the facts of this case. With regard to the second assignment of error, the trial court erred and abused its discretion by treating the bank loan obtained by husband David's sister, Randy Schneider, to pay off the mortgage debt owed on the marital residence and essentially save it from the 2012 foreclosure case filed by Third Federal Savings and Loan against David. By treating that loan obtained by Randy as somehow being an increase in marital equity in the residence and awarding $19,275 of that alleged increase in equity to Caroline. Given the leasing formula of reducing the original $29,000 in equity owed by David to Caroline from the first divorce. That $719 a month in rent over the course of nearly 3 years in which she lived there between the end of the first marriage and the second marriage, which took place in October of 2010, over $25,000 in that equity amount, which was owed by David to Caroline, was reduced, leaving an amount of approximately $3,800. And so we have no dispute with the court's calculations there. The dispute is that this was not a gift by Randy Schneider. She expects to be repaid by either David or by the eventual sale of the home if David is unable to repay her. The transfer to Randy was necessary in order for her to have security for this loan. Could it have been handled better? Could they have gotten David to sign a note to Randy? That would have been preferable, but my client is not a sophisticated person. He's a high school graduate going through some difficulties in his job, so they didn't do that. But the testimony of Randy makes it clear at trial that she was going to be repaid one way or the other. This was not a gift to her brother. Therefore, we would argue and ask this court to reverse on this assignment of error as well, insofar as there was no $19,000 or $38,000 increase in equity with $19,000. The court determining erroneously that $19,275 was owed to Caroline. With respect to the third and final assignment of error, this deals with a motor vehicle that was acquired by David shortly before the second marriage in 2010, a 1995 Ford Crown Victoria. It was left in Caroline's possession when the parties separated in 2011, and then it was returned to David in a deplorable condition. There was testimony at the hearing from Sergeant Mangle of the Medina Township Police Department, to whom David made the report when he got the vehicle back in such a deplorable state. She testified as to the extreme damage done to the vehicle, and photographs which she took were entered into evidence at the hearing. It's our contention that the court erred and abused its discretion in not requiring either payment of the $1,500 value of that vehicle or set off against other monies owed by David to Caroline with respect to the damage done to that Crown Victoria while in Caroline's possession. The court accepted his valuation of the vehicle as being worth only $600 subsequent to all of the damage, but then added insult to injury by requiring him to pay half of the value of the damaged vehicle to Caroline as part of the property settlement in this case. Given that Caroline or someone else, while the vehicle was in her possession, did severe damage to that vehicle, it's our contention that the court abused its discretion with respect to not allowing David to set off of the value of that vehicle and then subsequently ordering him to pay half the value, or $300, to Caroline for that vehicle in the property settlement. Based on the arguments set forth in the brief and made here today, we would ask that this court sustain the 3 assignments of error and reverse the judgment of the trial court below as to the spousal support order of indefinite $340 per month until the death of either party, remarriage, or cohabitation of Caroline with an unrelated adult male. 2, to reverse the erroneous award of $19,275 to Caroline, which was mistakenly characterized as her half equity interest, resulting from the payoff of the $38,550 third federal savings and loan mortgage debt on the marital residence that was owed by David and was paid for by his sister with expectation of repayment. And to number 3, the failure to find Caroline in contempt and or order her to pay David $1,500 either directly or in set-off monies due to the damage to his motor vehicle, and the erroneous order for David to pay Caroline $300 for her interest in that damaged vehicle. We would ask for remand with instructions to redetermine spousal support based solely on the duration of the second marriage in light of the fact that spousal support was dealt with in the first decree and no jurisdiction was maintained, to remand with instructions to void the erroneous order that David pay $19,275 to Caroline based on the Key Bank loan of $38,550 to pay off the mortgage loan balance, and to further remand with instructions ordering that Caroline either pay David $1,500 for damage to his vehicle in either cash or set off against the amounts owed by him to her, and to void the order that David pay Caroline $300 for her interest in that vehicle.
Thank you.
Thank you.
The court will take the matter under advisement. A written opinion will be issued and sent to both sides. Thank you for your presentation. And the court is adjourned until Thursday.